The court was deeply saddened to learn of the death of Lord Walker of Gestingthorpe on Friday of last week. Lord Walker was a Lord of Appeal in Ordinary between 2002 and 2009, and a Justice of this Court between 2009 and 2013. He was an immensely respected judge, careful, courteous, and wise. He was also the kindest of men. When I joined the court, he was one of its most senior members and almost 20 years older than me, but no one was more welcoming or more helpful. He was a man of deep feelings. I remember, for example, a moving speech he gave at the High Commission in Ottawa when he recalled the sacrifice of Canadian servicemen during the Second World War and described the memorial to the men of the Royal Canadian Air Force at Lincoln's Inn Fields. But he also had an acute sense of humour, which can be glimpsed in some of his judgments and was evident at his valedictory, which can be viewed on YouTube. Robert read classics at university before turning to law. For the motto on his coat of arms, he chose some words from Book 1 of Virgil's Aeneid, Mentem mortalia tangunt. Mortal things touch the heart. Those words encapsulate our feelings today. Our thoughts and our profound sympathy are with Lady Walker and her family at this sad time.
Hearing in view of Kireeva against Bedzhamov.
As it is.
My Lords, my Lady, I appear with Mr. Wilson for the appellant, learned friends Mr. Fenwick and Mr. Robbins, both at King's Counsel, and for the respondent, and learned friends Mr. Scott, King's Counsel, and Mrs. Rathi appear for the intervener. My Lords, there is a private transcription service, so there will be transcripts produced of the proceedings. I don't know whether your Lordships would be mindful of that and perhaps suggest a break at some point in the morning or go straight through.
Yes, if the transcribers would benefit from a break mid-morning, then we can aim to rise for 5 minutes. If you find a convenient moment, about, say, 11:45 time.
We have agreed a timetable. You will have seen we will open until about 2:30. Mr. Bedzhamov will respond until 11:45 tomorrow morning, and that will be followed by Mr. Scott for the intervener for 30 minutes, and then a reply finishing at 1 o'clock tomorrow. Following an introduction, we propose to address the issues in the same order as we have in our case. So with an introduction setting the scene, that will be followed by a short piece on the factual background. Then we will address thirdly the immovables rule. Fourth, the remedy of receivership in section 37. Fifth, modified universalism. And then sixthly, we'll deal with ground one, the immovables appeal, and our 7 reasons set out in our case. And it's proposed that Mr. Wilson will address you on reasons 4, 5, 6, and 7. And finally, we will say not a lot about the case of the intervener, and still less, eighthly, on the set-aside appeal. My Lords, my Lady, the appellant, Ms. Kireeva, is the Russian trustee in bankruptcy of the respondent, Mr. Bedzhamov. The bankruptcy order and the trustee's appointment have been recognised by order of the High Court dated the 6th of November 2022. The trustee's primary function is to realise the assets of Mr. Bedzhamov to pay his creditors, and for that purpose she seeks assistance at common law to protect and realise a substantial property registered in the name of Mr. Bedzhamov, known as 17 Belgrave Square. This appeal raises a narrow legal question, namely whether, and if so to what extent, the English court has power at common law to assist a recognised foreign trustee to protect and realise immovable property of the bankrupt in England, and we referred to that as the power issue. Mr. Justice Snowden and the majority of the Court of Appeal decided that the English courts have no power at common law to give any assistance in respect of the Belgrave Square property. They found that to do so would be inconsistent with the immovables rule, the rule of private international law that the vesting of a bankrupt's English immovable property in his trustee under a foreign bankruptcy is not recognised under English law as the lex situs, such that they found the English law cannot assist. In his dissenting judgment, Lord Justice Arnold gave reasons for his conclusion that such a power does exist. He found at paragraph 116 of his judgment that it was not disputed that the English courts have power to appoint a receiver in respect of the property. This was, he said, because Mr. Bedzhamov is the sole registered owner of it. He's subject to the in personam jurisdiction of the English courts. And so reasoned Lord Justice Arnold at paragraph 126 that the appointment of a receiver would not be inconsistent with the immovables rule, and that it would be consistent with the consequence of recognition of the trustee. And finally, he concluded that there was no other good reason to justify a finding that the court was unable to assist the trustee. Now, determination of this issue, the power issue, involves an examination of the role of the common law in cross-border insolvency. That's a subject that is closely reviewed in 3 modern cases. Chronologically, they are the Privy Council in Cambridge Gas, this court in Rubin, and then the Privy Council again in Singularis. Those are important decisions involving cross-border corporate insolvency. Although it is common ground between the parties that the power issue is very unlikely to arise in the context of cross-border corporate insolvency, and we've dealt with that at paragraph 28 of our case. So that in this appeal, the focus is on the role of the common law in cross-border personal insolvency or bankruptcy, where the power issue has significant relevance. If I may, I think I'd like to take you first to Rubin, which you will find behind tab 13, page 605 of the authorities bundle.
Just to unpick a little bit what you've just said, the reason why the power issue is unlikely to arise in the context of corporate insolvency, I presume, is because the assets remain vested in the company. There's no transfer of ownership.
My lord, yes.
Yeah. Whereas in a personal bankruptcy, of course, the assets that fall within the scope of the bankruptcy vest in the trustee.
Yes. And my lord, in cross-border corporate insolvency, recognition is effectively recognition of the authority of the liquidator to deal on behalf of the company with the property.
And the basic problem that you face here is that the asset in question remains vested in Mr. Bedzhamov.
My lord, yes.
And the problem you face is that you're trying to find a way by which an asset, you're trying to find effectively a way to deprive Mr. Bedzhamov of an asset which remains at present vested in him.
That's very much the way that the respondents put it.
Well, is that not an accurate way of putting it?
Well, my lord, it is as a matter of title,
Yeah.
but we will come on to the effect of recognition in due course.
But how high do you put your case? Do you limit your case to what Lord Justice Arnold said, which is Mr. Bedzhamov is in the jurisdiction, he's within our in personam range, we could injunct him to do everything he can to transfer the property, but another way of doing it is just to appoint a receiver over that asset of his, or is that Is that as far as you are going, or are you seeking to abrogate the immovables rule in a bankruptcy context? In every context, how high do you put your case?
It may be, in answer to that, a good time to emphasise what this appeal is not about and what we're not arguing. So, first, we are not arguing that the property has vested in the trustee under Russian bankruptcy law. We're not inviting the court to disapply any rules of private international law. And we are not trying to enforce the Russian bankruptcy law. We are simply seeking assistance in respect of it. And we do say that Lord Justice Arnold's approach is the correct approach, and it is the one which we say reflects the settled law up to the time when Mr. Justice Snowden gave his judgment. And
can you just your first proposition there? You're not arguing that the property has vested in the trustee, and I just didn't quite catch what you said after that. Did you say as a matter of Russian law?
yes. It has as a matter of Russian law,
It
in the
has,
sense that
yes.
Russian law
But
treats
not
it.
as a matter of English law?
My Lord, yes.
Not right.
So in other words, we are respecting the immovables rule. That is why we're here. We are seeking assistance because of the immovables rule. Otherwise, we could simply write to the land registry and suggest that we should be registered simply by dint of the Russian bankruptcy order, which we do not do and do not allege.
At some point, I'd also, not now, but at some point, I'd like to understand what you see the route going forward. So what would actually happen if a receiver were appointed?
Yes. Well, the receiver is appointed with the power of sale. Well, I should say, if this appeal is allowed, there will then be a stage 2, when the court will decide whether to appoint a receiver. That's the first question. If at that stage, in principle, the court is minded to appoint, and a receiver is appointed, first the court will impose such conditions as it seems just to protect creditors in this jurisdiction, and that is intensely fact-sensitive. The receiver will then, subject to those conditions, be appointed with a power of sale, and in due course will sell, and then the order appointing him will also deal with the proceeds.
The point is to give the receiver a power to sell somebody else's property without that person's consent.
Well, of course, that's in a sense the point of recognition. The effect of recognition is to recognise the status of the trustee and the status of Mr. Bedzhamov as a bankrupt, and the fact that we have authority to get in his assets worldwide and distribute them under the Russian bankruptcy regime. And that is the source.
But you have
the power to make the order.
You have the Russian trustee has the right to get in and realise the assets which form part of the bankrupt's estate.
Yes.
And as a matter of English law, the English property does not form part of the bankrupt's estate.
That certainly the Russian bankruptcy order is not treated as operating on the title.
Well, when you say the title, I mean, that doesn't just mean legal title, that means any interest in the property, doesn't it?
My Lord, it does, but the recognition brings with it recognition of the fact that we are getting in his estate, and his estate includes, obviously, his property in England.
His bankruptcy estate?
Yes.
But as a matter of English law, the effect of the immovable property law is to exclude his English immovable property from his bankrupt estate.
And that is why there are, I was about to go to Rubin, the now 3 gateways through which one can gain assistance from this jurisdiction in order to achieve that because of the immovables rule. So the immovables rule, section 426 in the CBIR and indeed common law, all take subject to the immovables rule. And what then happens is that whichever gateway you use, you come to court in order to get the assistance of the court, in effect, to get around the immovables rule, in recognition of the fact that you are getting in his worldwide estate.
But when the receiver, suppose a receiver is appointed by the court, who gives the instructions to the receiver?
The court. It's the court-appointed receiver. And the receiver acts under the direction of the court. So if he has a power of sale and he or she wishes to sell, they come back to court and get a direction for that purpose as a court-appointed receiver.
And what happens to the money?
Well, the court will then make a direction in respect of the money, and that will depend on how stage 2 goes, where the court considers which local creditors, as it were, if any, should have a say in the distribution of the proceeds, which is the purpose of the assistance route, because it's subject to those considerations.
So the distribution of the proceeds of sale of the entity wouldn't necessarily be governed by the rules governing distributions under Russian law.
But my lord, no. They only residually, in the sense that if one takes a silly example, there being net proceeds after cost of sale of £100, if after the court has decided that £40 of that must be paid to either secured creditors or other creditors, the 60 is then given to the trustee, and that is then obviously subject to her functions in Russia, as it were. But it's an important part of our submissions that each of the gateways which are available in these sorts of situations, I'm not saying to my client, but the 3 gateways which we'll come to in a moment, they're each subject to the immovables rule, and they each represent an ability in the court to assist, notwithstanding the immovables rule, by directing, if necessary, the appointment of a receiver and sale, or some other relief in respect of an immovable. And I was about to go to Rubin, if I may, on page 605. If I can pick it up, paragraphs 11 and 12 of the judgment. Paragraph 11.
Can you give us the page?
Page 620, I'm so sorry, Lord Collins' judgment. In paragraphs 11 to 20 under the subheading Insolvency Proceedings in the International Dimension, Lord Collins makes 5 general remarks, the first of which is at paragraph 11, where he refers at paragraph 12 to the case about the Scottish bankruptcy, Galbraith and Grimshaw, and identifies, and this was in 1910, what we still say is the law, namely that not so far as the general principle is concerned, it's quite consistent with the Comity of Nations. It should be a rule of international law that if the court finds that there is already pending a process of universal distribution of the bankrupt's effects, it should not allow steps to be taken in its territory which would interfere with that process of universal distribution. So we see that in a more modern form in singularis in due course, but that's the overlying principle. In paragraph 13, he deals with winding up. Paragraph 14, he deals with the international cooperation between and the pressing need for that in cross-border insolvency. Paragraph 15, he says there's no international unanimity about the detail of insolvency law. And finally, in this section, in paragraphs 16 to 20, he deals with universalism at 16 as a trend, and then modified universalism at the end of 16. And at paragraph 20, citing from the American decision of Re Maxwell, he picks up on this point, which is part of modified universalism, namely that the assistance is, and I'm looking at the quotation in paragraph 20 from Maxwell, reserving to local courts discretion to evaluate the fairness of home country procedures and to protect the interests of local creditors. So that's just setting the scene as to where we are with cross-border insolvency at a high level. More mainly, the next section, which is subheaded International Cooperation and Assistance, could I ask you to go to paragraph 25 on page 624, where Lord Collins lists 4 main methods, as they then were under English law, for assisting insolvency proceedings. His method 1 is at paragraph 25, and that's section 426. Method 2 is the now all forgotten EC insolvency regulation. Method 3 is the cross-border insolvency regulations. And he notes there that Article 7 reserves the common law. And at paragraph 29 on page 625, method 4, at common law, the court has a power to recognise and grant assistance to foreign insolvency proceedings. Common law principle is assistance may be given to foreign office holders in insolvencies with an international element. Now, although the entry criteria for each gateway is different, the UK no longer fulfills the criteria for method 2, EC insolvency reg, and that leaves, therefore, the CBIR 426 and the common law. Obviously, this appeal directly concerns Lord Collins' method 4, the common law. For your lordships, my lady's note, there's a penetrating article about method 4 by Mr. Andrew Godwin of Melbourne Law School and others, published in 2017 by the International Insolvency Review. It's entitled The Inherent Power of Common Law Courts to Provide Assistance in Cross-Border Insolvencies. And you'll find that at page 2846 of the authorities bundle. And they refer to the multiple gateways, and they weigh up the pros and cons very carefully at the end of their article. I'll come back to that briefly in due course.
There's an interesting passage in paragraph 17, one goes back to 622, where it's talking about universalism and its meaning, and cites Story, the theory that assignments under bankrupt or insolvent laws were and ought to be of universal operation to transfer movable property in whatever country it might be situate, and concluded that there was great wisdom in adopting the rule that an assignment in bankruptcy should operate as a complete and valid transfer of all the bankrupt's movable property abroad as well as at home. That's the... And then Cheshire, in the following paragraph, again, is talking about universality in relation to movable property. One sees that in the text and in the citation.
And then, my lord, he then comes up to date with Lord Hoffman and Maxwell, and I think in the subsequent decision of in Singularis that the courts speak with one voice on this in terms of the modern approach to modified universalism. But certainly back in 1834, Story and others had a different view. My Lords, it is part of our case, an important part of our case, that with the exception of bankruptcy orders made in Scotland and in Northern Ireland, the immovables rule applies whether assistance is sought under the CBIR, under section 426, or at common law. In each case, the foreign trustee uses the particular gateway to seek relief to mitigate against its effect. And we should perhaps clarify from the very outset what we mean by section 426. For this purpose, it might be best to go to it, which you'll find at page 872 of the authorities bundle. Because when I refer to section 426, I really mean section 426, subsections 4 and 5.
Sorry, the page again, please.
I'm so sorry, it's 872.
Thank you very much.
Now, subsections 1 and 2 deal with the enforcement, and that's the word used, shall be enforced, of intra-UK bankruptcy orders. And it's worth noting here that Lord Collins in Rubin at paragraph 152, that's page 650 of the authorities bundle, distinguished heavily sections 1 and 2 and their operation with against subsections 4 and 5. Subsections 4 and 5 are not about enforcement, they're about assistance. And subsections 1 and 2 are special, and they have their own special dicey rule, which is Rule 207. And dicey Rule 207 is on page 2710 of the bundle, the authorities bundle. And if I could just quickly ask you to turn that up. Here we see that an assignment of a bankrupt's property to the trustee in bankruptcy, I mean, 1 is Scotland and 2 is Northern Ireland, is or operates as an assignment to such trustee of the bankrupt's immovables and movables wherever situate. So that's a true statutory exception to the movables rule. And you will notice that that is in fact subject to a statutory qualification in subsection 2 of the 426, and that's explained at the top of page 2711, the next page of the authorities bundle. The foregoing principles must be read in the light of section 4262, which basically says the English court is not required to enforce the Scottish order, and so forth. And so there is a bright line, a distinction between Scotland and Ireland on the one hand and all other countries and territories to which section 426 applies on the other. The latter come to England, as it were, subject to the immovables rule, but they gain assistance under subsections 4 and 5, if appropriate. And this, in turn, is reflected in dicey Rule 209. Could I just ask you to look at that to complete this point?
You said, if appropriate. I just note that 426 is mandatory.
My Lord, it is. And as we'll see in due course, there's quite a bit of case law about this, probably culminating for modern purposes with the judgment of Lord Justice Morritt in Hughes and Hanover, where the judges have agreed at various levels that, whilst it is expressed in mandatory terms, there inevitably is a discretion, and there are quite a few cases where a court has, as a matter of discretion, declined to give assistance.
Thank you.
What is the discretion if the statute says that the property vests in the trustee, and the court then exercises its discretion not to enforce that? To whom does the property belong then?
But the property at all times belongs to the bankrupt. And the trustee is appointed, obviously, over the bankrupt's estate. And if it's an intra-UK bankruptcy, the court will recognise the vesting. But if it's not an intra-UK bankruptcy, then the court will assist the trustee, to put it bluntly, to get around the immovables rule. And we see this, if I could just ask you to go to Rule 209, which is the bankruptcy, bespoke Dicey rule for bankruptcy. It's page 2717 in Dicey, in the authorities bundle, I'm sorry. The rule itself provides an assignment of a bankrupt's property to the representative of the bankrupt's creditors under the bankruptcy law of any foreign country other than Scotland or Northern Ireland is not and does not operate as an assignment of any immovables of the bankrupt's situate in England. So the carve out there is obviously by reference to Rule 207 for Scotland and Northern Ireland. But in a proper case, the English court may authorise the appointment of a receiver of the rents and profits of such immovables. And then one sees in the comment at 31-097, a foreign trustee who would otherwise be met by the obstacle contained in this rule may be able to mitigate its effect if the English court in a proper case is prepared to appoint a receiver of the rents and profits of the immovables, and we know that means with the power of sale. Furthermore, the trustee may be able to invoke the assistance and then either under 426 or the CBIR. And then we've got the note in relation to Mr. Justice Snowden's judgment, who didn't find that this rule was in any way wrong, but you see there how it's put.
Are rents and immovables to be treated as immovable property themselves?
Well, rents...
Sorry, rents and profits, I'm sorry.
Yeah, rents and profits are receivable. We would say they are movables.
Yeah.
But, of course, the receiver is appointed, in effect, over receivables, as opposed to the property, technically.
What about proceeds of sale?
Well, they are. We say they are movables. They're cash. The rule isn't defended.
Even though it's in substitution for
Absolutely.
Immovable property.
So if on day one, on Monday, contracts have been signed to sell, but it's not due to complete until Tuesday, and on Monday the bankruptcy order is made, Tuesday the proceeds arrive, then the proceeds are movables and invest in the estate. That's our case.
But
there's no need
then,
to... I'm so sorry.
What would happen then if the person, the solicitor, say, with the registered charge, puts in their own receiver, that receiver sells the property, what then is the nature of the proceeds of sale?
Well, assuming that that receiver is appointed by a charge holder that is a prior charge holder,
Yes.
the prior charge holder will necessarily have a proprietary interest to pay its own secured indebtedness, and the balance then would be payable to Mr. Bedzhamov, but he is bankrupt, and the trustee, through the assistance route, whichever gateway he wants to use, would then want to attach to the proceeds as movables.
Mm-hmm. No, that's really
But I thought you were saying he doesn't need any assistance because that's then a movable.
Well, in these cases, the assumption always is that the bankrupt here will need an order of the court. The trustee needs to intervene simply because he needs to make sure it happens. Otherwise, the bankrupt will, as it were, disappear with the funds. That's the premise is the bankrupt's not cooperating. So that the trustee's remedy would certainly, in that example, if the trustee doesn't know about it, as it were, until the sale has taken place, they would simply assert that it's a movable because it's now proceeds. And if it's not a movable for some reason, again, they'd want assistance in relation to the immovable now represented by the proceeds. But very much subject to any valid encumbrance.
As I understand it, this is really the whole purpose of your application. The intention is that although the immovable property doesn't vest in the trustee under English law, if a receiver were to sell it, then in principle, and subject no doubt to other claims on the fund, the proceeds of sale would vest. Would certainly vest under Russian law, and that vesting would be recognised by English law.
My Lord, we go a little further because we would be asking the court to make directions in relation to the proceeds of sale under its ability to give assistance at common law. And we say that, and I'm sorry to labour this point, I'm conscious it sounds like repetition, but that assistance could be, depending on the facts, under the CBIR, under the 426(4), or at common law. Each of them is a gateway, and in each case, assistance, we say, on the facts of this case at least, would be the same. Could I, in fact, just very briefly make good that last point? Could I ask you to go in the authorities bundle to page 760, which is the cross-border insolvency regulations. We know that these obviously are in force here and that they are not available to the appellant trustee. But what's interesting for the purposes of the appeal is if one goes to page 763 of the authorities bundle.
Sorry, I missed your page number.
763.
73?
763.
76.
I'm so sorry, I misheard you. Thank you.
763, I hope that will take us to Regulation 7. Mm-hmm. And Regulation 7 is basically replicating Section 426. You'll notice Regulation 7.1, it talks about the intra-UK enforcement of orders. And Regulation 3, staying with only intra-UK, talks about the court's ability to assist other bankruptcy proceedings within the UK. So that's preserved. And again, in the same format, in other words, you enforce the orders or you assist. Can I jump on just quickly to Article 7, which is on page 769.
Oh, I see.
And that preserves the common law. Again, chiming with this idea that there are multiple gateways.
Sorry, where are we?
Nothing in this law
yes,
limits the power of a court or British insolvency officer to provide additional assistance by a foreign representative. And that's, for your Lordship's notes, as referred to by Lord Collins in Rubin at paragraph 27 on page 624. That's the background in terms of the gateways.
Well, while you're here, can you just show us the gateway which would be relevant in this case if the CBI are applying?
It's 21E, my lord.
This is Article 21E, is it?
Which is at, forgive me, 777. So it's Article 21 is on page 776. At 2, Seven 776. Upon recognition of a foreign bankruptcy, a foreign proceeding, whether main or non-main, where necessary to protect the assets of the debtor or the interests of the creditors, the court may, at the request of the foreign representative, and then do various things. And over the page, E, entrust the administration or realisation of all or part of the debtor's assets located in Great Britain to the foreign representative. So again,
I imagine that's common ground to apply to immovable as well as movable property.
my lord, yes. So again, no automatic vesting recognised, but the power to assist by entrusting administration or realisation. Now, my Lords, we respectfully agree with Lord Justice Arnold at paragraph 125 of the judgment. For about nearly 100 years, it's been settled law that the court can assist a foreign trustee, either under section 424(4), if available, or at common law, to obtain, control and realise English immovable property. The common law remedy is to appoint a receiver under section 37 with a power of sale. This has always been achieved exercising the court's general inherent jurisdiction, and that's regardless of whether the gateway was under section 4264 or at common law, provided obviously that the particular gateway is available on the facts. It is ironic that Mr. Bedzhamov paints our case as if we are proposing something radical and risky. In fact, we're being conservative and relying on conventional wisdom. And can I make good that point by asking you to go to the edition of Dicey, I think it's the 5th edition, in 1932, which you'll find at page 2612.
Can you just give the page again, please?
It's well, the front page is 2611.
Right.
You'll see it's the 5th edition from 1932. On page 2612, we have what is now Rule 209, what was then Rule 123. An assignment of a bankrupt's property to the representative of his creditors under the bankruptcy law of any foreign country other than Ireland or Scotland is not and does not operate as an assignment of any immovables of the bankrupt situated in England. But in a proper case, the English courts may authorise the sale of English immovables by such a representative. And for your Lordship's notes, this is, we would suggest plainly where, or at least the source of Lord Hoffman's comments in Cambridge Gas at paragraph 19. That's at page 452 of the authorities bundle. And it's interesting to see how in 1932 it was put. Could I ask you, under the comment, to look at the second full paragraph? It may indeed be laid down in broad terms that according to the doctrine maintained by English courts, a bankruptcy in one country has no effect of an assignment or otherwise on land in another country. But this statement is a little broader than the facts warrant. There is no reason to suppose that English courts would decline to recognise the extraterritorial effect as an assignment of a bankruptcy in one country, Victoria, on land of the bankrupt in another, New Zealand, which was given to a Victorian bankruptcy by the Lex Citus, by the Act of the New Zealand legislature. Further, whilst there is no provision in any imperial act giving colonial acts as to vesting of immovables in the trustee of a bankrupt extraterritorial validity, the requirement in the Bankruptcy Act 1914 that courts throughout the empire should aid, assist, each other in effect enables a bankrupt's immovable property to be made available for his creditors in whatever part of the British dominions. It's subject of course to all charges on it valid by the Lex Citus. Moreover, English courts will at their discretion confer authority on the trustee under a foreign bankruptcy to sell English immovables and to apply the proceeds to meet claims against the bankrupt. The rule therefore approximates in effective result to the result of Rule 124, which is the next rule relating to movables.
The authority cited is Cooperman, which no doubt we'll be looking at some point.
It is, but of course, can I just pause there? The authorities under Section 426, which relate to the same subject matter and the same point, are equally of force. And the reason that they are is that we know that under Section 426, the immovables rule is just as much in operation. And as I'll show you in a moment, it has been authoritatively stated after a review of the authorities that when the court under Section 426 appoints a receiver, it does so under its inherent jurisdiction. It doesn't do so under, as it were, the powers conferred specially by Section 426. And so it makes no difference if the appointment is made under Section 426 or at common law as a gateway, because in either case, the court is not exercising a statutory power, it's exercising its equitable jurisdiction to appoint receivers. And to make good that point, may I now take you to Hughes and Hanover, which you'll find at page 456 of the bundle. It's a corporate insolvency case, page 456. It's a decision of the Court of Appeal in 1997. The facts are not terribly relevant. It was an application for an injunction under Section 37 to restrain proceedings in the UK and more relevantly elsewhere. The application was made by way of a request for assistance by the Bermudan court on behalf, in effect, of Bermudan provisional liquidators. That's the background. The case is interesting for three reasons. The first two reasons can be found in the headnote, and I'm not going to read out to your lordships or my lady the facts because I've sort of summarised them sufficiently, I hope. But may I read out the holding? And it may be that it is just worth, as it were, having to hand in terms of at least having the page number, which is 872, section 426. The wording of section 42610 of the Act stated what the words insolvency law mean and not merely what they included. The definition had to be given as wide an ambit as possible so as not to inhibit the court from exercising its general equitable jurisdiction. Similarly, there was nothing in section 4264 which excluded the general jurisdiction and powers vested in the court. Indeed, the reference to insolvency law in section 4264 served to identify which courts in the UK had an obligation to assist a requesting court. The purpose of section 4265 was to extend the jurisdiction of the court in England so that when faced with a request, it was able to apply either the insolvency law of the relevant country concerned or its own insolvency law. Now, pausing there, it's important to emphasise that on this appeal, we are not inviting and have not invited the court to do either of those things. We are not inviting the court to apply the insolvency law of this country, nor indeed the insolvency law of any other country. Obviously, we are not a 426 case, but it's important to emphasise that we're not doing that. And then, thus, once assistance has been requested under 426, the English court has the power to apply, and then there's a list of three available systems of law. The first is the court's own general jurisdiction and powers, and then secondly, either English insolvency laws provided by the Insolvency Act 1986 and...
Sorry, where are you reading? Forgive me. Where are you reading?
Oh, in the holding on page 456.
Yes, all right. Sorry. So, right, okay, thank you.
I'm so sorry. So it's...
you can, the English court has power to apply, A, its own general jurisdiction and powers,
That's the common law,
and either B, English insolvency law,
yes,
or C, so much of the foreign insolvency law.
Absolutely.
As corresponds to that in B.
And then he then continues, in the case of B and C, and then importantly not A, the court in England was entitled to apply such law on the hypothesis that the matters specified in the request fell within the jurisdiction of the court applying the insolvency law under consideration. And then, moving on to a different point, once the court was seized of the matter, its function was to consider whether, in accordance with A, B and C, assistance might properly be granted, or if it was not possible to do exactly what was sought, it could assist in some other way. And then it goes on to say that notwithstanding the fact that the section 4264 appears to be mandatory, there's a power to refuse, and then explaining why in that case the assistance was not granted. Now, what Lord Justice Morris did in this case is he reviewed the case law under section 426 and its predecessors. Could I pick it up, please, looking at the authority pagination at 464, page 5.
You said you had 3 points that came out of this case.
Yes, I did.
2 were in the headnote. At the moment, I think you're dealing with the first one.
The first 2.
So
perhaps
you
you could
separate out 1 and 2.
Yes,
so I
you're quite right. I'm sorry, I'm going too fast. I'm conscious of the time. I'm so sorry. The first point is that, contrary to what was submitted to the Court of Appeal, under section 426, there are 3 systems of law, the first of which is the common law.
That's the ABC.
The second point is that the statutory hypothesis doesn't apply to A. Doesn't apply, as he says as he said there in the headnote. In the case of B and C, but not A, the court in England was entitled to apply such law on the hypothesis that the matters specified in the request fell within the jurisdiction and so forth. So in relation to A, if for instance under 426 you are asked to appoint a receiver, you don't get into any need for a statutory hypothesis.
So you read A, B and C as being 3 alternatives, do you?
Well, I think what Lord Justice Morris is saying is that when you're applying for a receiver, I don't need to get involved in pretending that in some way you're coming to me on the statutory hypothesis.
I see.
I don't need to. It's not something I'm asked to do. Don't need to do it.
It's just that it's expressed as being A, its own general jurisdiction and powers, and either B or C. So I was reading that as, well, as it is written.
Yes.
Rather than as being 3 alternatives, as I think you're suggesting now.
I think what he really means is that if you...
Well, this is the head note. This is
yes,
not actually...
so maybe...
It is indeed, and I think if we can go to what is said on that in the judgment, we'll find it... it's at page 476. And you'll see it at letter C. And indeed it's and.
476. I see.
Where do we start?
It's between B and C, after referring to the analysis of Mr. Justice Chadwick and Dalholt Estates. Thus, there is available to the court in England when asked for assistance by the court under 426 A, its own general jurisdiction, and either B or C.
So the next, and then in the case of B and C, but not A, the court in England is entitled to apply such law on the hypothesis as to jurisdiction, etc. So if you're just looking at A, you can't apply, for example, the foreign law, is that right?
Yes. And
so that might be a bit unhelpful to you.
Well, my lord, the text, if I can put it this way, or the context in which he says it, is, if I can go back to what he does here, he looks at page 466. I should say that perhaps going back to 465, he tracks back the previous provisions. So going backwards from 1986, it's section 122, the foot of the page of 465 of the 1914 Act, and then section 118 of the 69 Act, of the 69 Act, and 118 of the 83 Act and 74 of the 69 Act. And having done that, he finds that they're all, for present purposes, in the same terms. And he says at letter D at 466, there appear to be only 4 reported decisions of courts in England and 1 in Northern Ireland concerning the construction or application of sections 46(4) and 5, which bear on any of the issues we have to decide. And the cases he looks at are first, Re Levy's Trust, second, Galbraith and Grimshaw, and he quotes from Lord Macnaghten at the foot of that page. The Act does not say that a Scotch sequestration shall have effect in England as if it were an English bankruptcy of the same date. It only says that the courts of the different parts of the UK shall severally act in aid and be auxiliary to each other in all matters of bankruptcy. He then, over the page at 467, refers to Re Osborne between A and B, and notes in that case that a receiver was appointed. At the foot of the page, he refers to Re Jackson, a Northern Irish case. And finally, on page 468, he refers to Re Adetta, or Mr. Justice Goulding, I think, which is a movables case where a receiver was appointed. And he concludes that in each of the cases, this is now 474, page 474, prior to 1986, the ones we've just looked at a decanter, in my view, he says at letter D, this historical survey of the authorities and statutory predecessors of section 426 reveals a number of material propositions. First, in all the earlier cases, the assistance afforded to the requesting court was the result of the exercise of this court's general equitable jurisdiction. Thus, receivers were appointed in Osborne, Jackson and Re Adetta so as to give control over the assets here of the person made bankrupt in the other jurisdiction. And there was no suggestion in either of the earlier statutory provisions nor in the cases that the courts here were somehow limited in their jurisdiction to afford assistance in what they were entitled to under the express provisions of the Act. And second, the orders made in each of those cases recognised in the conditions imposed that issues between the trustee and third parties would have to be determined by due process of law. Thus, the trustee was required to submit to the jurisdiction and to abide by the decision of the court here in all matters concerning the assets of the bankrupt in England. And third, it was not the intention of Parliament when enacting Section 426 and its predecessor to restrict the jurisdiction or ability of the courts in England to afford assistance to the courts of the other parts of the UK or any other relevant countries or territories. And fourth, where the cases decided under the earlier legislation are all ones in which the court exercises its general jurisdiction, or those decided under 426, in which the assistance sought to be given are examples of courts exercising a jurisdiction conferred specifically by the Act, or its general powers as ancillary to such jurisdiction.
Earlier, or ones which the court exercise general, all this decided under 426, for example. I see. But is the point he's addressing here as to whether the court under 426 is restricted to particular remedies or orders conferred by statute, or whether it includes general powers?
It is.
It's not saying anything about the relevant law to be applied.
Well, in each case, it's accepted that if the court's exercising its general jurisdiction, it's recognising necessarily that the lex situs applies.
No, but it's just dealing with what the remedies are.
He is.
At this point, he's
Yes.
dealing with the remedies. But on the point then is how you can't, you need something more, don't you, to disapply the immovables rule.
You do,
And isn't that where B or C comes in? Back to the A and either B or C. And that's where C comes in, the foreign bankruptcy law.
My Lord, we would say not at all. We would say that the gateway is either common law, CBIR, or 426. In each case, the insolvency rule applies.
A and either B or C.
But if you've only got A, you're still doing exactly the same
How
thing.
do you overcome the immovable property rule if you just apply A?
Because you're recognising that the immovables rule applies.
Yes.
You say, I accept that there's been no vesting in me. That's why I'm coming for assistance. And I'm coming for assistance in order to, in recognition of my status and authority.
But isn't the way it works that under C, the court, the English court is able to say, well, under Russian, but under Australian bankruptcy law, the real property forms part of the bankrupt estate. And therefore, we can exercise powers, whether they're powers under the general inherent powers of the court or statutory powers or specific Insolvency Act powers.
The difficulty with that is that what you don't do is you don't look at the, in this case, the foreign trustee as having it vested in him, because the Section 426 is subject to the immovables rule. It doesn't get around the immovables rule.
Well, you achieve the same result, don't you? You make orders which does vest the property in the trustee.
Well,
so that's applying an English remedy to make an injunction or whatever, an order or a vesting order, and it's applying the substantive Australian law that says that this is part of the bankruptcy estate.
Well, my Lord, that's where I think, our company, what we say is that all that's happening under 426 in relation to an immovable is that, one, the letter of request comes in, triggering the jurisdiction. Secondly, the court can give assistance by appointing a receiver over the rents and profits with the power of sale, and it does that under its general jurisdiction, and it does it recognising the immovables rule. That's where I think we're on. It doesn't suggest
it overcomes the immovable rule, doesn't it? I mean, it maybe recognises it, but then says that we're entitled by statute to disregard it.
But then, with respect, they're not under Section 426. That's our position.
I see.
But I thought your case would be, yes, it may well be that at this point it was thought that you did need to have A plus either B or C, but what Lord Justice Arnold says is that now, post-Cartier, where you can grant equitable remedies to somebody who has no actual recognised right, you can just have A. You don't need now either B or C.
Well, that is what Lord Justice Arnold says. That's how he approaches it, and we have made it clear that we consider, with very great respect, that is the way to look at it.
So
the only reason
426 is a bit of a dead letter, then, I suppose.
Well, first and foremost, it isn't, because 426 obviously applies to a vast array of different situations. Immovable property is a tiny part of that, and it's largely used, as my Lord probably appreciates, in corporate.
But I mean, in HIH, for example, the House of Lords split as to whether remission or remittal of assets to Australia could be achieved at common law. The majority decision is that it required the exercise of powers under 426. Now, does it follow from the submissions you're making to us now that was wrong?
No, it doesn't. First, my Lord, I think I'm right in saying it was 2-2 on
well,
on that.
Lord Phillips didn't express a view, but he agreed with Lord Newberger and Lord Scott. So I think I'm right in saying that the majority, the ratio, is as I've described. It's a decision under Section 426.
Yes, I'm not going to split hairs about this, but
No.
I think Lord Collins had a slightly different way of putting it in singularis. But, my Lord, the bigger point here is that in the remittal case, there are two competing statutory schemes. That was the problem.
Yes.
And so this question doesn't arise here. There's only one statutory scheme. It's the Russian.
Why couldn't the court just, under its general equitable jurisdiction order, make an in personam order against the English liquidator, interim liquidator, to remit the assets to Australia?
Because that would have been arguably inconsistent with the English liquidation. There isn't an...
But as I understand your argument, it's under 426. You just You just provided there's jurisdiction to make the order can be made.
But on the particular facts of HIH, there are two competing systems, and so one is entitled to say, I have a problem here with the fact that there's an English bankruptcy and an Australian
There are two
bankruptcy.
competing systems in our case.
Well, my Lord,
You've got the Russian system, which says that the property vests in the trustee. You've got the English immovable rule, which says it doesn't.
well, but the English immovable rule, of course, is a common law rule, to which there are exceptions.
Well,
And that's, in a sense, what the question is the rule violated at all if one recognises that it remains vested in Mr. Bedzhamov, but it's accepted that the trustee has been appointed as his trustee in bankruptcy to get in his assets, and those assets include his English immovable property. And the next question then becomes, well, how does one assist in that? And our case is that in giving assistance, you're not violating the immovables rule, you're respecting it.
But we're going round in circles. As we discussed this earlier, the English law doesn't recognise the property in England as being part of the assets which are within the scope of the Russian insolvency.
My Lord, I think the way we see it is that what it doesn't recognise is that the vesting pursuant to the Russian bankruptcy order. What it does recognise is that under Russian bankruptcy law, the trustee must get in Mr. Bedzhamov's property.
no, I think that's you're going to have to make good that proposition, because the effect of the immovable property rule is surely to say that the English located real property is not within the powers of and duties of the Russian trustee.
Well, my Lord,
Just not part of the bankrupt's estate.
well, it's not been vested in the trustee, but under...
Well, I think it goes further than that. I don't think that does English... You're saying that English law recognises the powers and duties under Russian law of the trustee in relation to English immovable property.
My Lord, yes.
All it doesn't do is vest it in the trustee.
My Lord, yes. And it's entitled to recognise that is the position.
Isn't the Russian trustees... the Russian trustees' powers and duties are restricted, aren't they, to the assets forming the bankruptcy estate?
I would put it the other way round. The immovables rule is concerned with only two things. The first is that English law will not recognise a statutory vesting. That's number one. That's Rule 140. And the second is that any decisions about the English immovable is something which must be decided under English law, applying English law. And English law includes the assistance of a foreign trustee and the application of the principles of modified universalism.
I think the immovable rule has the effect that the trustee has no right or interest in the English property. Would you agree with that?
No property right, but she does.
She has a statutory duty under Russian law.
And her function is to get in his property, whatever that takes. And that includes coming to a foreign jurisdiction, here England, and asking for assistance to get in the English immovable. And that's the sort of nub of it.
Yes.
We're going to have to... we have to be quite careful about modified universalism. I mean, we looked at Story and Cheshire, who expressly confined the principle to movable property. And Lord Hoffman describes, he doesn't go into the details of whether it's movable, immovable, or both, but he does describe it as a long-established principle, which would suggest he's not intending to innovate on what was said, for example, by Cheshire. So if you're wanting to persuade us that universalism or modified universalism encompasses immovable property as well as movables, then we haven't yet seen authority for that proposition. Now, I see it's 11:45. Is this an appropriate point for us to have a short adjournment?
It certainly is.
Very well, then. We'll adjourn. And we'll resume in about 5 minutes or so. Yes, Mr. Davis.
Lord, you're about to go to modified universalism insofar as it impacts on the question on this appeal. For these purposes, could I ask you to go to the decision in Cambridge Gas, and in particular at page 452 of the bundle within the judgment of Lord Hoffman at paragraph 19. He starts the paragraph by referring to the undeveloped state of the common law, meaning that unifying principles which apply to both personal and corporate insolvency have not been fully worked out. And then he says, for example, the rule that English movables vest automatically in a foreign trustee or assignee has so far been limited to cases in which he was appointed by the court of the country in which the bankrupt was domiciled, and so forth, or to which he submitted. It may be that the criteria for recognition should be wider, but that question does not arise. Submission to the jurisdiction is enough, and in the case of immovable property belonging to a foreign bankrupt, there is automatic vesting, but the English court has a discretion to assist the foreign trustee by enabling him to obtain title to or otherwise deal with the property. And that, as was pointed out by both Lord Justice Arnold and Lord Justice Stuart Smith, is not a statement that not only survived the criticisms of Cambridge Gas, but it's not a statement that's been in any way disapproved of or subsequently overruled. What is more, if one turns to singularis within the judgment of Lord Sumption, paragraph 12 on page 675, page 675, paragraph 12, the first half of the paragraph is dealing with corporate insolvency. About 5 lines up from the foot of the page, Lord Sumption says, moreover, while the same rule did not apply to immovable property, the court could ordinarily appoint the foreign office holder a receiver of the rents and profits, and then he refers to Dicey. And that is then picked up in this case by Lord Justice Arnold at paragraph 124. That's in the core bundle at page 234. In the previous paragraph, paragraph 123, Lord Justice Arnold looked at the difference between proceeds on the one hand and the property itself on the other, and at the end of the paragraph thought it would be desirable to have the same approach to proceeds as one has to the property itself. He then went at paragraph 24 on to say this. The appellant's case receives support from Lord Hoffman's obiter statement in Cambridge Gas, and he sets that out. Although aspects of the reasoning in Cambridge Gas have subsequently been discredited, the principle of modified universalism remains part of the common law, as Lord Sumption explained in Singularis, and that was quoted by Lord Justice Newey earlier at paragraph 87. The principle dictates that English courts should, and then subject to local law and local public policy, cooperate with the courts in the country of the bankruptcy to ensure that all the bankrupt's assets are distributed to the creditors under a single system of distribution. English courts can only act within the limits of their own statutory and common law powers. That includes any proper development of the common law. And then in 125, he addresses the power to appoint a receiver as a well-established power of the Court of Equity, can be applied to new situations. As Lord Hoffman's dictum in Cambridge Gas suggests, modified universalism provides a principal basis for exercising the power in the present context. Although Cooperman is of little weight as an authority, and I'll go to Cooperman shortly, it's not one that has previously been judicially doubted or attracted adverse academic comment. On the contrary, then he lists all the leading commentators and jurists who cite it with approval. Thus, the endorsement of the decision by this court would not represent some radical departure from existing law, rather would amount to putting the existing law on a sound footing. And then over the page at 126, he identifies, if you like, what right it is that enables the trustee in a case like this to seek assistance through Section 37 of the Senior Courts Act. He says, second sentence, as I have explained, the immovables rule is a choice of law rule which results in the application of English law to questions of title to immovables. The bankruptcy context has the effect that the English courts will not simply recognise a foreign office holder's title to an immovable under the foreign law, but it does not mean that the foreign office holder has no rights at all in respect of that immovable. On the contrary, a foreign office holder whose appointment has been recognised by the English courts has the right to apply for the assistance of the English courts in realising assets falling within the estate for the benefit of creditors. And he goes on to say that's not inconsistent with Rule 217, because what's being sought is assistance in the exercise of discretionary power available under English law to make an in personam order appointing a receiver in respect of the immovable. And then goes on to make the point that in exercising that discretion, the court can, in effect, have regard to local law, local public policy, including, obviously, the rights of creditors in this jurisdiction.
The implication of that is that rights to real property will depend on the exercise of a discretionary power by the court.
Well,
this is an observation.
The property belongs to the bankrupt. The real point is that this court has recognised formally that he is bankrupt, and that there is somebody who has been tasked to get his property in.
Yeah. Well, obviously, it's going to cease to belong to him if a receiver is appointed with the power with a power of sale.
Yes, and the reason it ceases to belong to him is because it does form part of the estate in Russia. It's just the problem is that the bankruptcy order in Russia is not recognised as operating as a vesting. So the court does recognise it's part of the bankruptcy estate in Russia.
Well, that's a sort of irrelevant question for the English court. There's no concern to the English courts what forms part of the estate in Russia. What's important is what's part of the estate in England, isn't it?
Well, my Lord,
I mean, I've overstated that, but the real. I mean, there are two. I mean, there are perhaps a number of controversial points in this paragraph, which is really the key paragraph in Lord Justice Arnold's decision. But the first is where he says in about line 8. That although English courts don't simply recognise a foreign office holder's title to an immovable, it does not mean the foreign office holder has no rights at all in respect of the immovable. What's his authority for that?
Well, the foreign office holder has been appointed, in effect, to stand in the shoes of the bankrupt, just as we see that in English law, and in order to get in the estate. And
well, let me interrupt you, Mr. Davis. I accept what you say as a matter of Russian law, but what Lord Justice Arnold must be referring to here, surely, is what the position is in English law.
Yes.
So what's the basis for saying that under English law, the foreign office holder has rights in respect of the immovable?
It's referable to the fact that under English law, the trustee has been recognised.
Okay, and that under Russian law, the trustee's powers and duties extend to real property wherever situated.
My Lord, yes. And it's got nothing to do with vesting of title, that's really the point, which is what the immovables rule is all about. It's to do with the management of the bankrupt's affairs with a view to achieving the universal distribution of his assets.
Well, the right to which Lord Justice Arnold is referring is the right to apply for the assistance of the English courts in realising assets falling within the bankrupt estate. So he's not so much speaking of an existing proprietary right in relation to the property, but some sort of right, the only effective exercise of which is the making of an application to court.
Because of the immovables rule, the trustee must come to England and, applying the lex citus, must ask for the court's assistance, recognising that the property has not vested automatically by dint of the bankruptcy order.
But isn't this the point at which Lord Justice Stuart Smith parted company with Lord Justice Arnold, said you can have all the in personam jurisdiction you want, but the trustee has no entitlement to the property which would justify the court giving it to her, effectively.
And where we respectfully part company with Lord Justice Stuart Smith and Lord Justice Newey is that they did not accord really any importance to the effect of recognition and what recognition does. And we say that recognition is formally accepting that the appellant has been appointed under Russian bankruptcy law to get in worldwide his assets. And that his
assets, including the real property in England.
Yes, and the immovables rule doesn't stop the court from recognising that. What the immovables rule does is to say, well, however, the statutory vesting in Russia has no effect here. It doesn't, as it were, tip-ex out the fact that in Russia this is part of the Russian estate. And the question is, can they help the trustee to get it in, recognising that it hasn't vested?
So, I mean, you're very much focusing on vesting, which suggests that it's a sort of legal title point. But supposing Russian law operated by conferring on the trustee a worldwide power of attorney to deal with all assets belonging to the bankrupt. I mean, you would say, well, there wouldn't be a breach of the immovable property rule for the English courts to recognise that Russian statutory power of attorney.
My lord, absolutely.
Yes, right, I see.
And the reason for that is that one is not at any stage suggesting that the bankruptcy order in Russia, ipso facto, of its own force and effect, created a vesting. So the court has before it a person who it recognises has the authority to get in and realise property. And the question is, how can assistance be given? May I try to follow on from those remarks by placing them in the context of how Section 37 works? Starting with paragraph 79 of Lord Justice Newey's judgment on page 222. At the top of the page, perhaps I should have started on the previous page, but page 221, paragraph 79, just to show you that he's referring here to broad idea. And the question here is the ambit of Section 37 of the Senior Courts Act. And he says, over the page 222, looking at Lord Legate's reasoning in broad idea, he eventually comes to paragraph 52 of Lord Legate's judgments, where Lord Legate said, there can be no objection to this proposition insofar as it signifies, and this is now the test we would submit, the need to identify an interest of the claimant which merits protection, and a legal or equitable principle which justifies exercising the power to grant an injunction to protect that interest by ordering the defendant to do or refrain from doing something. And Section 37, obviously, a just and convenient test applies both to the appointment of receivers and to the making or the granting of injunctions. And we say that this test applies across Section 37. Now, if we now jump forward for a moment to Section 102 of Lord Justice Newey's judgment, we see him applying that test to the facts of this case. Page 229.
Paragraph what?
102. In the first sentence, he accepts that there's jurisdiction in the strict sense to make the order. He then refers to Masri, Tasarruf and broad idea, confirm that the power to grant injunctions and more relevant receivers under Section 37 is not fettered. in my view, it could not be proper for the court to use the power to circumvent the immovables rule. The immovables rule has the consequence that in the eyes of English law, Ms. Kireeva has no interest in or right to the Belgrave Square property. Russian law may say otherwise, it's irrelevant. That being so, Ms. Kireeva cannot be considered to have an interest meriting protection by the grant of a receiver or injunctive relief. It could not be right to make an order which directly or indirectly via the appointment of Ms. Kireeva with the power of sale involves the transfer of the Belgrave Square property to or at the direction of someone who, as a matter of English law, has no interest or right to it. And so we can see from that when applying Lord Legate's test, we say that Lord Justice Newey was blinkered because he refers only to having no interest in or right to the property. We get that from the that being so in paragraph 102. Whereas the way we would invite the court to look at this is as follows. If one splits up the test of Lord Legate into two, first identifying the right meriting protection, and secondly, looking for the principle justifying the appointment of a receiver or granting of relief under section 37. We say that Lord Justice Arnold, at paragraph 126, correctly identified that the relevant right which merits protection is the assistance of a foreign trustee, or the right to assistance of a foreign trustee who has been recognised. And that's a right to apply to this court for assistance by making an in personam order to appoint a receiver. We suggest that's not controversial.
But you don't protect the right to apply for assistance by appointing a receiver.
No, my lord.
You protect the right to apply for assistance by allowing the application for assistance to be made.
The question, I think, is going back to Lord Legate, to identify an interest of the claimant which merits protection.
Yes. Well, what is his interest in I will use neutral language. What is the trustee's interest in respect of the Belgravia property that requires protection? It can't be the. I don't see how the receiver can be appointed just to protect the right to apply for assistance.
Oh, my lord, I'm sorry. I understand the point. Sorry.
Yes.
No, what I'm
So
saying.
what is the right? That you said that Lord Justice Arnold correctly identified as the relevant right for the purpose of Lord Legate's test. As I understand it, the right to assistance.
It is, having been recognised, there is a right to active assistance from this court. And the question is...
Subject to local laws and policy.
Because it's a discretionary jurisdiction.
Yes, of course. At this stage, we're only identifying whether the court can.
Yes.
Whether it has the power to help. Whether it should is another issue.
It's not assistance in the abstract, if we go back to 126. It's assistance in realising assets falling within the bankrupt estate for the benefit of creditors. That may require one to think rather hard about whether the relevant asset falls within the bankrupt estate.
Which the court recognises that it does in Russia. It hasn't airbrushed that out. It just says that has no effect in England. That's how the immovables rule works.
If it has no effect in England, how is the existence of a right to apply for assistance to give it effect consistent with a rule that says it has no effect?
Well, it's the bankruptcy order. It's just the statutory vesting that has no effect. What we are relying on is that we have been appointed with statutory functions to get in his assets. And it's not in dispute that his assets include Belgrave Square.
I think that's the problem I'm having with your submission at the moment. his assets, as a matter of English law, do not include English immovable property. It's not, you refer to vesting, but this isn't just a question of vesting. It's not a question, I mean, vesting tends to suggest in whom is vested the legal title, and you accept that a vesting order can't be made under the Trustee Act. So it's not a question of vesting. It's a question of whether the trustee has any recognisable interest in or right to or power over English immovable property.
And again, we start with the immovables rule. We ask what are the four walls of that rule.
Exactly.
And we say that the four walls are that the statutory vesting in the foreign jurisdiction is not recognised as affecting title.
I don't quite know what actually, I haven't looked at it and it's my fault, but what actually is the position under Russian law in a sentence? Does it vest?
It's the same as here, as if
it is the same.
It's a worldwide vesting.
But, well then if it doesn't vest, what is the extent of the trustee's interest?
Well, it's like any asset that a trustee has to go out, as it were, and get, because there's a problem. I mean, and there are lots of clawback assets, which one says, well, they're vested in somebody else.
You need to take proceedings.
Yes.
But that presupposes that the vesting is recognised.
No, it doesn't, my lord. So that you can think of assets where you would say, there's an asset over there which should belong to the estate, but it doesn't for whatever reason, and you have to go out and get it.
Yes, but it's still vested, but you just have to take legal proceedings in order to recover it.
Well, it might be a clawback claim for...
But, well, never mind. Yes, all right. I think that's that's not really vesting,
No.
I don't think. That's a claim the liquidator or trustee can bring. But if we are talking about assets which exist at the time of the bankruptcy and are owned by the bankrupt, then if they don't vest, they're not part of the estate, are they?
They don't. I think it's the reason they don't vest. They don't vest because the English court doesn't recognise the effect of the foreign bankruptcy order. There's no statutory vesting. What the English court, in our submission, does recognise is that this is an asset which this trustee has been tasked to get in. Because
I don't think English law, I think that's the difficulty you have to overcome. I don't think that the effect of the immovable property rule is that English law will not recognise any foreign legislation purporting to confer rights or interests in English immovable property in anybody else.
Well, we do our company at this stage.
All right, well, that's a very important point.
Yes. We operate on the basis that the Dicey rules are accurate in the sense that they say that the foreign bankruptcy order doesn't, of its own force and effect, create a statutory vesting. We say it goes no further than...
Let's take it outside the bankruptcy context for a moment, because the the English immovable property rule applies across the board. Are there any authorities you can refer us to which support your submission that something less than vesting will be recognised in English law in respect of English immovable property?
Well, I would start, if I may, by looking at the converse. Could I ask you to go to page 941 of the bundle, which I hope is a decision of the Court of Appeal in Ashurst and Pollard.
921.
941.
Thank you.
And this is looking at the position the other way round before I answer my Lord Richard's question. So this is a decision of the Court of Appeal in the year 2000 relating to an English bankruptcy looking at a Portuguese property. And given time...
This is going to help you, is it? Because this is exactly the opposite way round.
Yes, it is.
And there's no doubt that as a matter of... Anyway, there's something in it that talks about what the effect would be if it was a foreign bankruptcy.
My Lord, it's page 946, within paragraph 16, there's just a neat encapsulation where the Court of Appeal, Lord Justice Jonathan Parker, cites from the judgment of first instance of Mr. Justice Jacob. And he says this: page 946, letter B. There's no doubt that English law regards the Portuguese landholding as vested in the trustee. To the extent that the trustee's title has not been perfected, the bankrupt is, by English law, holding it for the trustee. So the bankrupt can be compelled to complete the trustee's title or to do any other act in relation to the land at the trustee's direction. Any such order, provided it's in personam, is an order which the English court can make, having as it does jurisdiction over the bankrupt who is domiciled here.
Yes. Well, that's because of the effective English bankruptcy law, which vests the worldwide property of the bankrupt in the bankrupt's trustee.
But obviously the difficulty there is that it doesn't affect title in Portugal.
Well, no, that's a practical difficulty. So the way the English court deals with that is to make an in personam order against the bankrupt to take whatever steps are necessary to vest the legal title under Portuguese law in the trustee.
And I think that's we say that there's no difference in substance between that and our case.
Well, there is, because this is dealing with an English bankruptcy, and we're dealing with a Russian bankruptcy.
Yes,
and there isn't obviously an immovable property law rule applicable in the case of an English bankruptcy.
Well, there is the other way. The immovable rule applies to the Portuguese property.
Of course. So if the trustee went to Portugal and said, this is my property, the Portuguese court would say, no, it isn't.
Yeah,
and that's why you have an in personam order against the debtor.
And clear in the first sentence, there's no doubt that English law regards the Portuguese landholding as vested in the trustee.
Yeah.
And there's no doubt that the Russian law regards Belgrave Square property as vested. And this court recognises that that is the position under Russian law. But it also goes on to recognise that the immovables rule is such that it doesn't affect a change of title. So that in England, although it forms part of the Russian universal estate, no change has been made to title as a result of the bankruptcy order in Russia, and therefore one has to come here and ask for assistance. And that's the...
Can I ask, you're about having to ask for assistance, is there a reason why bankruptcy proceedings could not have been commenced in England?
Well, we've gone into that in some detail in our written case. There are quite a few reasons.
Right.
Probably the best thing, I'm going to ask Mr. Wilson to address you on that anyway. But first and foremost, we don't have standing to petition, and there are a host of reasons after that why we couldn't have done that. What in effect you do is you create two...
No, you wouldn't have had, the trustee wouldn't have had standing, but presumably a debtor would have had standing, a creditor rather would have had...
If you could find a creditor who was prepared to do that, you'd create a second bankruptcy estate.
Yeah.
With
yes, but it would be specifically to recover the English real property.
And as Lord Justice Arnold, with respect, correctly observed, that's almost the antithesis of modified universalism, because you're creating two bankruptcies rather than one, which is the very thing that the principle is designed to avoid.
But if in Russia they'd been able to require Mr. Bedzhamov to transfer his title to the trustee here, then of course that would transfer title and the English court would recognise that. But the question is, can you make him do that when you have no entitlement under English law to that property in his hands?
Yes, and that is where the bodies are buried, as it were, because that's the question of assistance. We come here because of the immovables rule. The property is in England, the bankrupt is in England, and we have been recognised as his trustee.
But you obviously place a great deal of weight on that recognition.
Yes.
Yeah.
And what is the aspect of that recognition that you say then places you in a better position vis-a-vis entitlement to the Belgravia property?
Well, my lady, paragraph 109 of Lord Justice Arnold's judgment, that's page 230. he described the effect of recognition as recognising her, that's my client's, duty and right to realise the assets comprising that estate for the benefit of Mr. Bedzhamov's creditors.
So this is paragraph...
109.
Sorry,
109 on page 230.
So this is in... Oh, I see. Yes.
And where...
Hold on. I think let's pause there. I mean, that's perhaps the nub of it, isn't it? Recognised her duty and right to realise the assets comprising that estate. Well, which assets comprise that estate in the eyes of English law?
I understand that. And that's where what we were discussing earlier. Our submission is that the recognition brings with it a recognition that under Russian law, this trustee has a duty and a right to realise this property because under Russian law it forms part of the estate. It also goes on to recognise that it hasn't vested.
Maybe reading too much into it. Because what does recognition mean? I mean, if recognition merely means, well, we understand what Russian law provides, I mean, that's recognition of no value at all. Recognition in this sense must have a real impact, and I would agree with the thrust of this, that it's a recognition of the rights and duties of the trustee as they apply in England.
And that, so far we're...
But that's the nub of the problem.
I don't think, with respect, that the English court says, I cannot see that you have a duty or right to realise an English immovable.
Right, it can't. English. I mean, you're suggesting that is what recognition involves. But that's not a right that English law will give effect to.
My lord, it is what the...
You say it is. It's within the jurisdiction of the court to do so.
Yes, because the English law recognises that it hasn't vested by dint of the bankruptcy order in Russia. That's the immovables rule, and that's the long and short of it. It doesn't go any further than that.
Is there anything you can point us to that suggests that that is what recognition of a foreign trustee entails? A recognition that they have the duty to bring in to realise, for the benefit of the creditors, all the property, regardless of where it's situated?
Well, my lady, the answer to that, I think, is that the Rule 209, the Dicey Rule 209...
No, I mean anything actually in the legislation that deals with the process of recognition. Is there something that says...
Well, there is no... that's the point. There is no legislation that deals with recognition at common law. There is no legislation that's applicable. And in fact, I was just thinking that we shouldn't run away with the idea that at common law recognition is some freestanding procedure or has some substantive effect. I mean, I think if you go back to the old cases, what happens is that the foreign trustee issues proceedings seeking an order of the court for payment of a debt or whatever, and the defence says, well, you have no right. And so the trustee in that action establishes that under Dutch law or whatever it is, he has become the trustee and is therefore entitled to seek that asset. It's not a sort of general recognition. So if you translate that into the terms of this case, the Russian trustee commences proceedings in England in the Chancery Division for an order against Mr. Bedzhamov that he transfer the Belgrave property to the trustee. And the problem is the trustee is likely to be met with the immovable property rule as a defence.
You have to come...
So there's recognition doesn't have some sort of freestanding significance here, truly. It is true that now the courts tend to make recognition orders, albeit at common law, but it doesn't really have any particular significance. It's only when you get down to the detail of the order that is sought that one has to look at this.
The fact remains that when you're recognising a foreign trustee, you are necessarily recognising first the status of the trustee,
Well, I'm coming back to the example I gave. Supposing that the trustee here had commenced proceedings in the Chancery Division for an order in personam against Mr. Bedzhamov, that he transfer the Belgrave property to her. He would have to plead Russian law as the basis of that claim. Why would that not be met by the foreign immovable, or the immovable property rule?
Because the tried and tested way of coming here is to seek recognition and assistance, not to start proceedings.
Well, you say that, but we go back 2 or 3 centuries to Solomon and Ross and so on, back in the 17th century. They didn't seek an order for recognition there. They just brought proceedings.
Well, let's look at a movable. Suppose the trustee thinks that he's got in a safe in the garden 3 gold bars, right? And she wants to get hold of those. So there's no immovables problem. So she brings an action in the Chancery Division, as my Lord Richard says, saying, give me those gold bars from your safe. And then she has to prove some kind of title to those gold bars. And she does that by proving that she's been appointed the trustee in bankruptcy in Russia and the gold bars are movables that are now vested in her. Now, then, before deciding to order him to give her the gold bars, is it that order that entails the recognition, as you put it, of the trustee's entitlement? Or could Mr. Bedzhamov say, I'm not giving her the gold bars because that is all a big fraud, that bankruptcy should never have been ordered, and is there then a fight over that, at the end of which the court would have to decide whether it recognises the bankruptcy to the extent of ordering him, the apparent owner of the gold bars, to hand them to her, whose only right derives from the now recognised bankruptcy? Is that how it works?
Our Lady, in that example, recognition must come first, in the sense that without it you get no automatic vesting. So once the trustee is recognised, then the court will recognise the automatic vesting of the movable in that example, which is why the foreign trustees come to this jurisdiction and first seek recognition and then assistance. Because without the recognition in the movables example, you don't get the vesting of the gold bars. And so conventionally, the trustee in this case has come and first sought recognition, and following recognition now seeks assistance. And the difference in the debate that we've been having is that I say that the immovables rule does not airbrush out the fact that in Russia, her functions are to get in his English immovables, recognising that that is something that has to be done in England, because the immovables rule operates to disapply the statutory vesting in Russia.
Mr. Davis, I see the time. Would I be right in guessing that you are under some time pressure?
A little.
Well, we'd better restrain ourselves. I think we've quizzed you pretty thoroughly on the issues that we've been discussing, so I think perhaps we should let you make progress.
I'm obliged. If I could just, in that case, gather myself for a moment. It may be a good time, finally, it's 25 to 1, to ask you to look at Cooperman, which is a delayed entry in the play. At page 582, which I hope is the edition, is the report in the weekly notes.
Yes.
Yes. Page 583, decision of Mr. Justice Asprey, we see Mr. Cooperman was a man of Russian origin, trading in Belgium, living in France, declared bankrupt in Antwerp. He submitted to the jurisdiction and opposed the bankruptcy order. Mr. Donnet was appointed as his curator or trustee. The principal assets were 2 leasehold houses in Walthamstow. You'll see there were 2 judgments of the court in Antwerp. The first authorised Mr. Donnet to sell the properties. The second directed Mr. Cooperman had been divested of all property, both movable and immovable, at home and abroad, and that Mr. Donnet alone had authority to realise and should sell. And you'll see that Mr. Donnet recognised before the English court, or acknowledged the effect of the immovables rule, which at that time was in the 4th edition of Dicey, referred to in the last paragraph on page 583. On that basis, he sought a vesting order, alternatively an order for the appointment of a fit and proper person as a receiver with authority to sell. And on the receivership point, counsel relied on Bergeron and Marsh, which, although first the bankrupt was a party in that case and the judgment only dealt with movable property, he said it showed that the English court ought to assist the trustee in a foreign bankruptcy to realise the assets in England. And Mr. Justice Asprey appointed Mr. Donnet as the receiver with authority to sell and to retain and deal with the proceeds.
So is this simply a decision on a motion?
It looks like it.
Yeah.
As we explain in our written case, I think we are entitled to say that this decision has been referred to without disapproval in every major textbook in this area, and we've listed the many works, or the principal works, at paragraph 45 of our case, from page 99. And it's clear that all the commentators and jurists regard this as an exercise of a discretion independent of any jurisdiction to recognise and assist under statute. And it has been followed, has been treated as correct in something like 10 editions of Dicey since 1932. And we're not aware that it's ever been challenged or doubted for almost a century until this case.
In Dicey, Dicey changes at some point, does it, on this?
It does. And
Do we know why?
I'm going to, yes. I'm going to go to that next, if I may. It certainly does, yes. And just to sort of herald that, if I may, the short point is that for nearly for about 8 editions, Dicey talked about the appointment with a power of sale, and that's from the 8th edition onwards until the 12th edition. This is paragraphs 48 and 49 of our written case.
Right.
And then subsequently was referred to the power at common law to appoint a receiver of the rents and profits of the immovables, without reference to the power of sale. Can I venture a suggestion as to why that is? You get the answer from re Osborne, which is on page 593 of the authorities bundle. Decision of Mr. Justice Farwell in 1932. This was a case under section 122 of 1914 Act. That's the predecessor of 246. 426. And you'll see on at page 593 the basic facts of Osborne. It was an Isle of Man bankruptcy, a trustee coming here, and there was an appointment of a receiver over English immovables. And the point to answer my Lord Richard's question comes up at page 601, page 197 of the report, 601 of the authorities bundle. And at the top of the page, Mr. Justice Farwell says this: I can appoint a receiver without security of the movable property, but I can only appoint the applicant receiver of the rents and profits of the freehold and leasehold property with liberty to sell. I cannot appoint him receiver of the immovable property. I cannot vest the freehold property in him. All I can do is appoint him receiver. I cannot appoint him receiver of anything more than the rents and profits of the freehold and leasehold property with liberty to sell and deal with the proceeds. Then after the interjection, he says this: of course, I'm only appointing you receiver subject to the rights of prior encumbrances. I think Mr. Justice Asprey, so that's a reference to Cooperman, appears to have appointed him receiver of the leasehold property, but I do not think that means anything more than a receiver of the rents and profits, does it? In the ordinary course, one appoints a receiver, and one does it very often in this court, sitting in Chancery. I think the effect of appointing a receiver in the case of freehold property, and I should think also in the case of leasehold property, is that he is appointed receiver of the rents and profits. And then further down the page, about 5 lines up, he says, the mortgagees might already be in possession, but subject to their rights, I can appoint you and I can give you authority to sell and retain and deal with the proceeds as trustee of the property of the bankrupt. We then see at page 603 the order that he made. It's the 2/3 of the way down the page. And this court doth order that the applicant be appointed receiver without authority of the rents and profits and other monies receivable in respect to the bankrupt's interests in the immovable property situated in England, with liberty to sell the same or any part thereof and to receive the proceeds thereof, but without prejudice to the rights of any prior encumbrances. And so in the earlier editions of Dicey, there was a reference in relying on Cooperman of the ability of common law to appoint a receiver with authority to sell. In the most recent editions, it talks about the appointment of a receiver to get around the immovables rule of the rents and profits, but actually on analysis that's the same thing, because the power of sale is the power of sale. And all Mr. Justice Farwell is saying is, well, I can only really appoint you a receiver of a receivable. And the receivable is either the rents, the profits, or the proceeds. And that's what I'm doing. And so we say that the successive editions of Dicey, and we've set them all out since the 5th edition, right up to the current edition, which is the 16th edition, 2022, all speak of the same voice. And so if we, it's right also that in that canter through the authorities, which is very quick, could I also show you the Scottish case at page 2021, 2021, of Araya and Coghill. Again, another case which is cited in the main textbooks on the issue of the common law right to assistance. Now, I've just remembered that in fact there are 2 versions of this, and I would prefer you see the fuller report, which I think is in the further supplemental bundle. You have that at page 2, I hope.
Yes.
Thank you very much. Which I hope is the report, looking at the top left-hand corner, page 462 of the 1921 Scottish cases.
I think people are just finding this, Mr. Davis.
Further supplementary bundle, yeah.
Further supplemental.
Yep.
Oh, I see.
Orion copy, yes.
Oh, yes.
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 And so this decision is referred to in the footnotes that I showed you in Dicey and in Sheldon and so forth. The petition, you can see, was presented by a Mr. Araya, who was the official receiver appointed by the court in Chile in relation to the sequestration of the estates of the late William Coghill, who was deceased and resident in Chile before that. Three types of relief were sought: confirmation of the sequestration, authority to sell Scottish heritable or heritage property, and authority to uplift certain proceeds of life insurance policies. It was opposed by Mr. Coghill's deceased son, Mr. Coghill's son. For one looks at the arguments at the bottom of the page, so it's page 4 or 464 of the report. I don't know if you have at the very foot of the page, the prayer of the petition is proposed to be amended.
Yes.
Pray for the court to confirm the sequestration and bankruptcy of the estates of William Coghill, the appointment of Mr. Araya as official receiver on behalf of the creditors of Mr. Coghill to authorise Mr. Buchan as attorney for the petitioner to complete title in his name as attorney. And in short, if you then go across to page 6 to look at Lord President Clyde's judgment, in the third full paragraph, he contrasts first, this is the paragraph which starts, before dealing with it, I ought to dispose of the proposed amendment with regard to the policies of assurance. In that paragraph, he deals with the universal title to the insurance proceeds as immovable. And then in the following paragraph, he says the questions with regard to the Scottish heritage, particularly in reference to the method by which the proceeds derived from the proposed sale ought to be disposed of among the persons entitled, may raise points of nicety. But the point which arises at present is that the sale, as the petition is framed, all we're asked to do is to grant authority to the official receivers mandatory to make up a title to the heritable property and to sell and dispose of it on such terms as the official receiver should direct, the net proceeds being presumably remitted to the official receiver in Chile. And he said, I don't think we would be justified in giving authority without ejecting the usual conditions as to the upset price and other terms, and he goes into that. And then jumping down the page...
Well, before we jump, he goes on to say, I understand that parties are in a position to amend the prayer so as to define the conditions upon which both petitioner and respondent are agreeable that the heritable estate should be exposed. So it seems not only was there no argument based on the immovables rule, but in fact both parties were content that the property should be sold.
Well, my lord, that is right, but it doesn't detract from the fact that what is happening here is that the foreign trustee has been giving assistance and the court is conferring on the foreign trustee the right to, in effect, to realise the property. And, of course, the opposition was the bankrupt's son. It's still, as a matter of jurisdiction, the court is exercising the jurisdiction to assist and to assist in the realisation of the property.
All that at the end of the day was authorised was an agreed sale, the proceeds of sale to be lodged in the hands of a court, and then the final disposal to depend on further argument.
Yes, yes, and that, which is what indeed if we went to stage 2, would happen in this case. Lord Skerrington then, in his judgment, said that the regularity of the appointment has not been challenged. It must therefore be regarded as conferring upon the official receiver a universal title to the movable or the personal assets of the deceased bankrupt, including the policies. And then it follows that the petition is proposed to amend the petition and so forth is refused as unnecessary. And then at 4 lines later, all that we have to consider is the application by the official receiver's attorney in Scotland for authority to sell a villa in Peebles. That is, of course, expedient for all concerned, and their interests will be conserved by the clauses and conditions specified in the order. And then he goes over the page. You see the order that was made, authorising the sale of the heritable property upon such terms and conditions as might be agreed between the parties, or failing agreement by the court, fixed by the court.
Yeah, the background, it appears from the Lord President's opinion that, well, the way he puts it is we're told that heritable property is at present unlet, and to use a cant phrase, eating its own head off. And so
Yes.
to prevent further loss, it was to be sold as soon as possible.
Yeah, well, Mr. Justice Miles, in this case, has decided that the property should be sold because of jeopardy and a diminution in its value as time passes.
Yes. But the difference was that in this case, the only person with a competing right was agreeable.
But that doesn't confer jurisdiction on the court as such. I mean, at the end of the day...
But there was no issue taken as to jurisdiction.
Lord, that may well be right. But, so there it is. That's a good working example, at least, of a foreign trustee having to get in a foreign immovable. There is also, I'm looking at the time, the decision in a case called Redrum, which is an Irish case. And
That's also in this further supplementary bundle.
I'll get back to the other one now.
oh yes, there was a corrupted copy of it. So it is. Thank you. It is in the supplemental bundle. I can't. Now remember whether my own copy is corrupted. Yes, 2306 in the original. And in this case, the US...
it's page 24, I think, of the
Yes.
supplementary.
I'm obliged. In this case, we see on the first page of the judgment, it was a Russian, an American a trustee under a voluntary bankruptcy system in Chapter 7 that came to the Irish court seeking to collect and get in an Irish immovable property. Did so at common law, and the judge, this is Justice Dunn, we see on the 3 pages from the back of the report, referred to Cambridge Gas, and in particular the principle of modified universalism, and she referred to what Lord Hoffman had said about the application of modified universalism, and in the end we see on the last page of the report exercised the inherent jurisdiction of the Irish court and made a vesting order in favour of the US trustee at common law. And we say that's a principled application of modified universalism, granting assistance at common law to a foreign trustee in respect of an immovable locally, that is to say, in the receiving court. Again, the way we put our case is that this is respecting the immovables rule. It is not violating it or in some way trying to get around it. It is recognizing it and therefore coming to the lex situs, seeking assistance for the purposes of the universal collection and distribution of the assets in the foreign bankruptcy. And we should emphasize that the Irish court here was relying squarely on that part of Cambridge Gas, which has certainly, we would say, survived criticisms that were subsequently levelled at it in Rubin and in Singularis. It was dealing with what I would call modified universalism, pure and simple. And that, just before the break, brings me to come full circle. And our case is, as I outlined at the very outset of my submissions, is that the ability to assist in these cases is not some statutory exception to the immovables rule. The ability to assist is a self-standing one at common law, and to the extent that a gateway is used either under section 426, which is not our case, or under the CBIR, again, there's no exception in our submission to the immovables rule. The court recognises that the Russian bankruptcy, or the foreign bankruptcy, has not operated to vest. It does not treat the person seeking assistance as the owner of the property. It treats the person seeking assistance as someone who has a recognised function to get in the property which is in the name of the bankrupt. And in all of the cases, what one sees when one talks about recognition is a recognition that the court's assistance can plainly extend to the immovable property, because the immovable property is in England, applying English law. Section 37 of the Senior Courts Act can be used to assist the recognised foreign trustee to get in bankruptcy estate, which, for these purposes, includes the immovable. And we say there is no tension between, on the one hand, recognising that the bankruptcy order does not operate ipso facto to vest the English immovable in the foreign trustee, on the one hand, and the ability of the English court, with the foreign trustee in front of it, to assist the foreign trustee to carry out their functions.
Thank you very much, Mr.
Can I
Davis. Is that
just
a-
ask one very brief, you mentioned earlier that the recognition order in this case was made, I think, on the 6th of November 2022. Perhaps after lunch you could just give us the reference to it. If you don't have it, could we have copies?
Yes, of course.
Thank you.
Very well. We'll adjourn and resume at 2 o'clock.